Thank you, Mr. Chairman. Today, we've heard basically infomercials or commercials for Obamacare from the other side of the aisle, but the purpose of today's hearing is about the separation of powers in government, the checks and balances, and the authorities bestowed upon the Constitution of the legislative branch to use those the legislative and executive branches. What we had here was a very unpopular law that was pushed through in a hurry with the election of Scott Brown. They know the law was flawed when it was passed. The House had different ideas about how this should go forward, and the perception by the people at that time, and I like Mr. Willey, was a practicing physician when this was passed, or 18 years prior to coming to Congress, and so I look at it through that perspective. But the people in the country did not like this concept. They didn't like it in the 90s. They didn't like it about 4 or 5 years ago because it represented in their mind a federal or government takeover of health care. The Senate knew, in fact, they implied in letters that I'll introduce in just a minute, that it would be better if they had a federal exchange or a national single payer. But this was widely rejected by the American people, and therefore it is my contention that it was their intent to avoid using the term, opposed to what Mr. Lazarus is saying, to avoid using the term federal exchange and focused on state exchanges because state sounded less like government takeover of health care. So this was by intent. I'd like to enter into the records a law review article from Professor Timothy Jost.
Without objection.
Okay. Mr. Adler, can we put that up on the screen, please? Mr. Adler, have you seen this law review article?
Yes, I have.
Okay. On page 7, Professor Jost writes that a way to get around the commandeering problem would be for Congress to exercise its constitutional authority to spend money for public welfare, either by offering tax subsidies for insurance only in states that have complied with federal requirements, or by offering explicit payments to states that establish exchanges for the federal requirements. Can you comment on whether or not what you found in your research would suggest that the Senate bill did do this?
The Senate bill is certainly written to do precisely what Professor Jost suggested that it could, and that had been done in prior contexts, as he notes, as with health savings accounts.
Okay. Who is Timothy Jost, and why is he relevant?
He is a law professor who is a very prominent expert on health law, and as far as I'm aware, was very involved in healthcare reform and in helping to develop ideas that were part of healthcare reform.
Okay. Mr. Chairman, I'd also like to enter into or ask unanimous consent to enter in the record a story from the NPR that references Democratic House members from Texas who wrote President Obama urging that the House approach be preserved in the final bill.
Yeah, without objection.
And also would like to introduce into the record a letter from U.S. Rep. Doggett and 6 of his colleagues, Democratic colleagues.
Yeah, without objection. Okay.
Basically, this letter is describing where in Texas they saw this problem coming as well, and suggested that they urged the President that the House approach should be preserved in the final bill. They worry that because leaders in their state oppose the health bill and they won't bother to create an exchange, leaving uninsured state residents with no way to benefit from the new law. So it wasn't an accident that federal exchange was left out, as Mr. Lazarus suggests, and for him to suggest that you, Mr. Adler, and the others on this panel are just engaging in self-defeating spin or just looking to find a glitch to bring this health care law down. Would you disagree with that, and what is your intent?
Well, as I mentioned before, I first wrote about these provisions in the law before I was aware of the way these provisions interacted with, for example, the employer mandate, and before it was clear that a majority of states would refuse to implement exchanges. To me, as a scholar of administrative law and federalism, it was interesting to see different ways in which Congress has tried to induce state cooperation in different in various federal programs. I'm also someone that's very concerned about the nature of congressional delegations of authority to agencies. And here, as in other contexts, if an agency departs from clear statutory text, that's a problem. And it doesn't matter whether it's the Health Care Law or the Clean Air Act or any other statute, and it doesn't matter whether it's a Democratic or Republican president. That's something that agencies should not do.
Thank you. Mr. Pruitt, could you quickly give us an update on where the lawsuit that you're engaged is in going, and what do you expect to occur in the near future?
Well, thank you, Congressman. We have fully briefed the motion to dismiss filed by the Federal Government, and that case was argued before the Court back in June, and we're awaiting the decision by the Court at this time. If I could, Mr. Chairman, I think it's important to remember that this Congress and Congress routinely uses spending power to accomplish something called cooperative federalism. And it's not unfamiliar to this committee. It's not unfamiliar to Congress. And I would say, Congressman Cartwright, with respect to the statement that's been made a couple of times that all citizens across the country were intended to be treated equally under the ACA, you know, in the Medicaid arena, routinely, states engage in cooperative federalism with Congress. Citizens are treated differently quite often. As you know, eligibility determinations are given to the states, and there's incentives to the states to match the appropriations of this Congress to cover, at times, more individuals. It might be surprising to the Congressman that in the state of Oklahoma, we've had a program called Insure Oklahoma that's been around since 2003, and it covers 30,000 individuals that could not otherwise afford health insurance. But CMS has notified the state of Oklahoma, despite that program being very successful at providing access to health care, because the state of Oklahoma has not expanded Medicaid under the ACA, CMS has killed that program and told the state of Oklahoma to cease operations under the 1115 Medicaid waiver that exists in the state of Oklahoma since 2005. So it is somewhat incongruent to say that a state, when it makes a decision that's been reserved to the state by Congress to decide whether a state health care exchange should issue in that state, we've made the decision. We are a proponent of the rule of law. It's not an opponent of the policy decisions that you have made in this Congress. We are seeking to give life and meaning to what you have passed in this body. And when an agency makes a decision that's inconsistent with that, when it makes a decision that's clearly against the plain reading of the statute, Mr. Lazarus has said on more than one occasion that the context of the statute justifies his position. It only justifies his position if you don't read the plain language out of 1401, Section 1401. You have to count that as surplusage in 1401 to say that somehow these statutes are harmonious with one another as far as providing benefits under a federal exchange. So this is something that, on a couple of occasions this morning, the motives perhaps of the state of Oklahoma in bringing this lawsuit have been brought to bear. I want you to know that the motives of my office, the Attorney General's office did not make a decision about whether to expand Medicaid. It did not make a decision about whether to adopt a health care exchange. We are simply giving life and meaning to the plain reading of the statutes, honoring the decisions that have been made by our governor and by our legislature and by this Congress. And I believe that every member of this committee should take seriously the language that's been passed by Congress to make sure that agencies heed that. Otherwise, rule of law is degraded, and that's what we're a proponent of.
Thank you. Mr. Woodall.